If you've just lost a loved one and you're in California, you're probably hearing words like probate, certified letters, Independent Administrations of Estates Act. I understand all of this can be very confusing and feel extremely overwhelming. But here's the truth. Probate doesn't have to be that way. And it won't once you understand the process step by step. And I'm going to show you everything you need to know. In this video, I'm going to walk you through exactly how to start probate in California, the forms you'll need, where to get them, what they cost, and how to avoid the mistakes that delay families for months. And by the end, you'll know exactly how to get probate started and the simple step most families forget to take that adds months of delay to their case. I'll show you how to get this right the first time. Stick with me. Don't skip away to watch cat videos, because by the 6-minute mark, that's where I'll reveal the most common mistake that I see families make when starting probate, and how to make sure you don't make the same mistakes and get stuck waiting for continuances and extra hearings. This one thing is so simple, but skipping it can stop your case in its tracks. I'm Gary DiGrazia Jr. Now, I'm not an attorney, and I do not offer any legal advice. But for 20 years, I've specialized in probate real estate, helping families navigate the court system and sell the estate home. I don't just help families directly, I also train other real estate agents nationwide how to properly and efficiently handle probate real estate sales. So today, you're not just getting theory or some chat GPT explanation on starting probate. You're getting the exact practical steps that families that I've worked with have used time and time again. I'll show you all the steps you need to follow. First things first, not every estate requires a full probate. California has small estate shortcuts. If the estate is worth less than $208,850 of personal property, you may be able to use a small estate affidavit instead of going through the complete probate process. And starting in April, if the primary residence is valued at $750,000 or less, you may qualify for a simplified transfer process. Why this matters? If you qualify, you can avoid months of paperwork and thousands of dollars in cost. But if there's real estate above those limits, you'll likely need a formal probate. And that's where we start with the petition. Preparation is everything. Before you even file, here's documents that you're going to want to gather. A certified death certificate, the original will, a list of assets like the estate home, any accounts, any vehicles, any business interests. You'll want contact info for all heirs and beneficiaries. Why is this important? Because missing just one relative's address or forgetting to attach the original will can delay your hearing by months. You'll also want to decide who will serve as the personal representative. That's the person who acts on behalf of the estate. And when you file, you'll want to request something called IAEA authority. With IAEA full authority, you can manage and even sell real property with far fewer court hearings. Without it, you'll be back in court for approval every time you need to act. Next, you'll file your petition for probate. That's Judicial Council Form DE-111. And you can download it right from your county superior courthouse. Now, along with that, you'll file the DE-147, the duties and liabilities of the personal representative. That's your acknowledgement of what the court expects you to do. When you file, You'll also submit the original will, if there is one, and you'll pay the filing fee, usually a few $100s, depending on the county that you're in. Now, here's where families get tripped up. In the petition, there's a section where you must list all heirs and relatives, even if they're disinherited from the will. You forget one, and the judge will continue your hearing to a later date. And this is that simple mistake I promised earlier for you to avoid. Not listing every required relative in your petition and notice is a huge mistake. It sounds small, I know, but the court is very strict. If an heir is left out, even if they're not inheriting anything, your petition will get delayed. This is one of the most common yet most avoidable mistakes that I see made. After filing, you'll get a hearing date. Then you must notify everyone. Here's how you do that. You complete Form DE 121. That's called the Notice of Petition to Administer Estate. You mail it to all required relatives and heirs. But, and this is important, you can't mail it yourself. A non-party must do it, and you must file proof. You must also publish that notice 3 times in a qualified newspaper of general circulation wherever the deceased lived. Why this matters? Notice is jurisdictional. If it's not done correctly, the court can't proceed. On your hearing date, if everything is in order, the judge will sign your order for probate, and the clerk will issue your letters of either testamentary or letters of administration. These letters are your proof of authority. With them, you can open estate accounts, pay bills, and most importantly, sell the estate property if needed. Without these letters, you legally cannot act for the estate. Within the first 120 days of getting your letters, you'll have some critical tasks. You'll need to open an estate bank account and get an EIN number from the IRS. You'll need to file your inventory and appraisal. That's the DE 160 and 161. A probate referee will value assets. Their fee is 0.1% of the total asset values, or a minimum of $75. Then you send notice to creditors, the DE 157, to anyone that the deceased owed money to. Now, these steps matter because they protect the estate. They create a record of assets and liabilities, which the court relies on when approving the distribution letter. So let's quickly review the typical costs to start probate in California. You'll have filing fees. Usually, it could be a few hundred to several $100s, depending on your county. Newspaper publication costs, which are, a few $100s more. The probate referee fee, 0.1% of non-cash assets. Bond premiums, if a bond is required. And later, attorney fees if you hired counsel, and their fee is set by the court. The earlier you file these, the sooner the timeline begins, and the sooner you'll have legal authority to act. Starting probate sooner protects the estate's value. Until you have certified letters, you can't manage the property. You can't pay taxes or secure assets. Vacant homes, unpaid bills, family disputes, they only get worse with time. Filing early means you'll have authority within weeks instead of months. So there you go. There's the step-by-step process to start probate in California. I know it's a lot, but when you take it piece by piece, it becomes very manageable. So if you found this video helpful, here's a few extra steps for you. Subscribe to this channel for weekly probate real estate tips. Download my free probate real estate guide. This guide will prepare you for what to plan for, what to expect when the time comes and you have the legal authority to sell the probate home. You can find the link to that download in the description. And if you'd really like to get on the right track, book a consultation with me so we can talk through your specific situation. When you book this non-obligation call with me, I'll answer all your questions and I'll point you in the right direction. We can talk about different ideas on how to save you money, and I can help you find the right attorney if you want or even need one. So don't wait. Don't avoid the sense of urgency with probate. Book your call with me right now. The link is also in the description, but you can also find it on the home page of this channel. I'm Gary DiGrazia, the pro in probate real estate. Thanks for watching, and I hope to see you in the next video.